Good morning, everyone, and welcome to our March Saturday morning breakfast conversation. We are just so excited that you have joined us on this morning, and we thank God for this opportunity to offer this ministry to our community for free. On this month, our subject is legal issues, the law and you. And we are so honored that we have attorney David Hamilton of Rowan Hamilton Law Firm of Indianapolis with us. He has been practicing law for over 32 years. He graduated from the Indiana University School of Law, and we're just so glad that he is here. He can share some additional information about his background. I know he, as well as other Indiana alumni, are excited right now because the
Yes,
team is performing well in the tournament. And so we wanted to offer this free ministry initiative that is sponsored by our church, Temple of Faith Church of God in Christ, and our 501c3 nonprofit organization, Faith Community Initiatives. And so we want to welcome all of you in. Those of you that are watching us live, we hope that you have grabbed your breakfast and enjoying your breakfast. I have my orange juice with me. And so hopefully we can enjoy some important conversation this morning with Attorney Hamilton, learn something to enhance our lives and the life of our community. So Attorney Hamilton, let me pass this call to you. Thank you for joining us.
Thank you so much, Pastor. I sincerely appreciate the opportunity and the invite to speak this morning. It is my hope that my words are a blessing and that I impart some knowledge to those that are listening. My plan today is to discuss two topics with you. The first being interacting with a police officer, and the second being landlord-tenant rights in the state of Indiana. So let's begin the first topic, interacting with a police officer. As many of you know, interacting with the police officer can be a stressful situation that can go bad quickly. I want to provide you with strategies and your legal rights for handling these situations. I think that what I impart today, you need to impart to family members, to your sons, to your daughters, and to other relatives to make sure that their encounters end up in their favor and that they are safe. It is my opinion that the burden of de-escalation does not fall on private citizens, but it falls on the police officers. They have been trained and should be properly trained to interact with you, to protect you, and to serve you. But we know from current and past events around our community and around the country that some officers may not behave in a way that keep you safe and respect your rights. So what should you do? And what are your rights if you have an encounter? First and foremost, you should stay calm. You should be polite, and you should not exhibit any hostility towards the police officers. This, in and of itself, can keep you safe. What legal rights do you have? You have the right to remain silent, which is guaranteed by the Fifth Amendment to the United States Constitution. Remember that anything you say can and will be used against you in court. So tell the officer that you wish to remain silent. Do not lie or give false or fake documents to the officer that can lead to an arrest. You have the right to refuse to a consent of yourself, your car, or your home. Do not argue with or obstruct the officer in his investigation if he later decides to make a search. That is something that you can handle through an attorney in court if the search itself found to be illegal. If you're not under arrest, you have the right to leave. Ask the officer if you're free to go. And if the officer says yes, you can walk away or drive away. If you are arrested, you also have the right to a lawyer. That's guaranteed by the Sixth Amendment to the United States Constitution. Tell the officer that you wish to remain silent and ask for a lawyer. Do not say anything, sign anything, or make any decisions without a lawyer. Do not resist arrest, even if you believe the arrest is unlawful or unfair. Do not flee or run from the scene. that can lead to bad consequences, as we all know. Even if you're not a United States citizen, you have constitutional rights that have been guaranteed by our laws in the state of Indiana and also by the federal Constitution. You do not have to consent to a search of yourself or your belongings, but police may pat you down, which is your outer clothing, if they suspect you have a weapon on your person. Note that refusing consent may not stop the officer from carrying out a search against your will, but making a timely objection before or during a search can help you preserve your rights in any later legal proceedings. A lawyer can file what's called a motion to suppress any evidence that the police attempts to use against you if the search is found to be illegal. If you are arrested by the police, you have the right to a government-appointed lawyer if you cannot afford one. What if the police comes to your home and they're at your door? What rights do you have to reduce the risk to yourself? I would advise that you not invite the officer into your house. You can talk with the officer to the door, and if they ask you, you can show them your identification. You do not have to let them in your home unless they show you a warrant that's signed by a judicial officer that lists your address as a place to be searched, or your name is on it and you're subject to an arrest warrant. Then you have to comply. Even if the officer has a warrant, you still have the right to remain silent. You should not answer questions or speak to the officers while they're in your house conducting the search. Stand silently and observe what they do, where they go, and write down everything that you observed. Also, if you've been arrested by the police, you have the right to make a local phone call. The police cannot listen if you call a lawyer. They can and often do listen if you call someone else other than a lawyer. And with these rights being exercised itself, the constitutional rights, what if you believe your rights have been violated? What steps should you take at that point in time? You should write down everything you remember, including the officer's badge and patrol numbers, which agency the officers were from, and any other details. You can get contact information from witnesses. I also would not ask the officer for his badge number. If you can observe it in that interaction, then do so. Most officers get upset and they know that you're going to file a complaint if in fact you ask for the badge number, and they may file, and they typically do file, disorderly conduct or resisting arrest charges in those type of circumstances from my experience. If you've been injured in your encounter with the police officer, you should seek medical attention immediately and take any photographs of your injuries. If you decide to file a written report, you do so with the Internal Affairs or the Civilian Complaint Board of that agency from which the police officer was from. Now, my topic is not all police officers are going to behave badly. I do not want to leave that particular impression. We have some very good officers in each and every community that serves us and protects us, but you need to know your rights when dealing with them. So it's very important that you exercise your rights itself, and that basically if you have nothing to hide, then basically just comply is what you should do. You still do not have to consent to the search, but definitely remain calm, be polite, and be respectful. Those can just de-escalate a situation that may go bad and protect you to live another day. I myself do not practice in the area of criminal law any longer. I've been in practice for 38 years, and my practice deals mainly with civil litigation. I'm a trial lawyer, but I have handled criminal cases in my practice of 38 years. I have sat as a criminal court judge on a pro tem and a special judge appointment basis. So those rights that I have spelled out to you are respected and known by the courts. So be very much advised in terms of those rights itself that you do have. The next topic that I want to discuss with you is landlord-tenant rights and what rights you have in the state of Indiana. So I want to transition to that topic at this point in time. If you are renting or leasing or looking to rent, you'll be presented with a contract, which is a rental or leasing agreement. That agreement itself and those four corners of that agreement spells out your rights and obligations as a landlord or a tenant. My advice would be that you seek a lawyer to review any documents or contracts that you're about to sign If you're not knowledgeable and there's language or obligations that you're unsure of, you do not want to give up any rights that are given to you by the statutes or the laws of the state of Indiana. What rights do you have as a tenant in the state of Indiana? If you lease or rent a premises, you have the right to have a safe, clean, inhabitable premise or dwelling. According to Indiana law, the landlord must comply with all building and health codes and provide a safe and clean dwelling for you to live in. This includes toilets, furnace, windows have to be working, locks have to be on the doors and the windows and also functioning. They have to keep the premises and the structures of those premises safe so they do not at any point in time cause any harm or danger to you or your family. The upkeep, who's responsible for the upkeep of the premises? The fixtures, the heat and appliances are the responsibility of the landlord. The plumbing, the electrical systems, they have to make sure those are in working order, in good condition, and that those are provided to you. Now we move on to privacy issues in the landlord-tenant situation. If a landlord wants to enter your premises, they must give you advance notice that they're going to enter the dwelling. And the only exception is if there's an emergency, such as a fire, a loss of heat, or a flood. Typically within your contract, they're going to basically tell you that they will give you notice to enter your dwellings and they have a right to basically enter to inspect. But notice has to be given to you and it has to be reasonable notice itself. How about the common areas of the dwelling in which you basically are living in? Landlords have a duty to maintain those areas throughout the rental premises. Common areas are those shared by all tenants, and they have to be basically free of trash, weeds, etc. And the sidewalks have to be in repair and good working order for you to basically walk and have a leadway or pathway itself. We all know that basically when we lease or we rent, we have to basically make a deposit. And that deposit itself has to be put into an account and maintained by the landlord. He can't use it for repairs or anything else. And that deposit has to be returned to you upon the termination of the lease. And what happens in the state of Indiana is that when you terminate your lease, either by the end of the terminacy or the period itself, the landlord has to give you an itemization of damages, if any, that was caused to the premises. And those damages are deducted from the security deposit. So when you leave your tenancy there, what you need to do is you have to give the landlord a forwarding address. And you should send that forwarding address to them by certified mail, in addition to basically dropping off the forwarding address, because you want to have records that you provided a forwarding address. So your deposit has to be returned within 45 days. After giving that forwarding address to the landlord, if they fail to send you the deposit within 45 days, by Indiana statute, your deposit has to be returned in full, regardless if damages itself were done, because they failed to comply with the laws. Those are tenant rights that you have. And I would say that in this state, we are one that basically have more rental properties, from my research, than most states. And your rights are enforced by the courts. Most landlord-tenant situations end up in small claims court. You do not have to have a lawyer to represent you in small claims, because those courts basically are courts that allow you to represent yourself. But if a landlord is a corporation, he has to be represented by counsel. And anytime the other party has an attorney, it would be basically prudent for you yourself to have an attorney to represent those particular rights. I'm going to move on to another topic that had not been planned, but one in which basically I do as a lawyer. And those, if you've been involved in an automobile collision, what should you do and what rights do you have? If you're involved in a collision in the state of Indiana, the first thing that you have to do is you have to stop and you have to exchange information on the scene. You should always call the police to have the police investigate the incident, to take statement from the parties involved. Also, if there's any witnesses on the scene, you want to get the names of those witnesses. You also would want to photograph the property damage. You would also want to make sure that you have insurance, because if you fail to have insurance, those have bad consequences. One of the consequences being that your license would be suspended for a period of 90 days for failing to have insurance. Indiana also passed what's called a no pay, no play law, which basically means if you've had an accident in the past and did not have insurance, then you only are entitled to collect economic damages. Those being basically your medical expenses, your wage loss itself, and your property damage. You do not get pain and suffering, which is intangible. You do not get any compensation for the injury sustained in the accident because of the past failure to provide proof of financial responsibility. In the state of Indiana, financial responsibility means that you must have a policy of insurance or be self-insured to the extent of $25,000. Is that sufficient? No, it's not sufficient. Medical bills in and of itself typically exceed $25,000. If you have to be airlifted to the hospital because of a very serious accident, that helicopter ride is going to cost you in excess of $25,000. Then you have the emergency room billings, et cetera. Then basically, once the accident has been investigated, if you have insurance, you should call your agent or the claims department to report the incident itself. If the other party's insurance company calls you, you should not give them a statement. That statement typically is used against you, and they twist it to make it sound like you're at fault for an accident that you may not be at fault for. So you should consult an attorney at that point in time and let the attorney basically handle the proceedings from that point forward if you're injured, or if there's a dispute about how the accident happened and your vehicle is not being taken care of, or your wages not being paid, or your injuries are not being compensated. So those are very important rights that you have in those regards. If you're involved in an accident, there are statute of limitations that are applicable. There's a 2-year statute of limitations for personal injury and property damage in the state of Indiana. So if the date of the accident happened today, you would have 2 years from today to either settle that claim or file the complaint with the appropriate court to basically have your rights protected. Failure to file means you'll be forever barred from collecting any compensation for your injuries or your property damage. But the filing of the complaint, if one is filed, the limitation, it doesn't necessarily mean that you're going to have a court proceeding within 2 years of the accident. Because of the pandemic and other things happening within our communities, the courts are backlogged on cases. So a case could pend for 2-3 years, depending on when it's actually filed. So it's best to make sure that your rights are protected by basically contacting an attorney that handles those type of cases on your behalf. What else in regards to personal injury that you need to know is that you should make sure that you document any injuries that you have. It's necessary that you keep a journal of basically the limitations of your activities, that you also basically note any doctor visits you go to make sure that those are written down, because sometimes doctors basically fail to either record a visit. It could be virtual, and you want to make sure that basically all treatment is noted and documented, because your right to compensation is based on a number of factors. They look at the liability aspect first. Indiana is what's called a comparative fault state. Fault has to add up to 100%. If you have any fault for the happening of an accident, then that percentage of fault is basically deducted from any damages that you would be entitled to. So if in fact you were 20% at fault, you would only get 80% of your damages is what you would end up being entitled to. If you're more than 50% at fault, then you are completely barred from any rights to recovery. And how do they basically evaluate your claim? They look at liability first, and we just talked about that. They look at the nature and extent of your injuries. They look at whether or not those injuries are temporary or permanent. They basically look at the reasonable and necessary medical expenses, and they look at any wage loss itself. And of course, you get compensated for property damage, and that's pretty easy to figure, that if you have a repair, then that repair cost is paid, or if your vehicle is completely destroyed as a result of the accident, then you get the fair market value of that vehicle is what you're entitled to. I believe that's the time that I had at this point in time, and I sincerely appreciate you listening.
Thank you, Attorney Hamilton. Great presentation. And I have proof that it was a great presentation because we have questions.
Wonderful.
The first question is, this person is asking, they need to understand what you said about a search warrant. They said if they don't consent to the search warrant, can the police still execute the search warrant?
If in fact the police actually has received a search warrant from a judge and signed by a judge, then you have to consent to the search warrant. What I basically stated is if the police does not have a search warrant, then he has no right to enter your home. Or if he
Okay.
basically he's trying to search your person, you don't have to consent to that search. He can do a pat down if he suspects you have weapons on your person.
So you said they can do a pat down. Can they go in our pockets?
No, they cannot. The only time they can go in your pockets is if they feel a gun or they feel a knife. But no, it has to be the outer clothing of your person. They cannot basically go into your pockets.
Wow. Okay. Okay. Because we see it happening a lot.
We do.
The next question is about tenant landlord rights. This person said that if they lost their job, they could not pay their rent. They did not see on the lease that they could not get their deposit back. They left the apartment very clean because they were only there 2 months. Were they entitled to get their deposit back?
No, as a matter of fact, the deposit probably will be used towards any past due rents itself, not unless the landlord actually terminated the lease because of loss of job. Then basically the deposit's been applied towards any past due rents or damages to the apartment.
There was no damage. They're saying there was
No damage.
No damage or anything. They left the apartment clean, etc. It's just they lost their job, couldn't pay anymore, and gave notice and moved out.
Yeah, the thing is that it depends on the term of the lease. If they gave notice, basically, if they're on a month to month, which is basically 30 days, because if you have a term lease, which is basically like 12 months, and you break that lease, then the landlord could sue you for the remainder of those damages itself. So if you have a 30-day month to month type term, and you give 30 days notice, then yes, they have to give you back your deposit. So it depends on the circumstances.
Okay. All right. Thank you. Now, we have another question about automobile accidents.
Okay.
You mentioned that, and I had a question about this as well, because I had never heard this, that if you don't have insurance,
no,
it limits your recovery. It doesn't matter how severe your injuries, your personal injury, etc. Can you elaborate on that a little bit? I had never heard that before.
Yes, that's a law that they just enacted about 5 years ago. We term it a no pay, no play statute. And what it says is if you have driven and had an accident and been uninsured in the past, then they're not going to compensate you and they're not going to basically reward you for basically being uninsured at the time of this accident. So if you have insurance, it doesn't matter that you had not had insurance in the past, but if you have an accident and you're not insured and you've been uninsured in the past, even though you were not at fault for that accident, you will not get anything other than your economic damages. You don't get the intangibles of pain and suffering. You don't get the nature and extent of your injuries. It's a very harsh law, but it basically is supposed to incentivize people to get insurance. So it's rough. And I see people come in all the time that have not basically were not insured, and they have the statute that's applicable to them.
Yes, I thank you so much for sharing that information. How widespread is that knowledge? That
I'm not sure it is. And that's why I wanted to bring that up. I have a friend that's an insurance agent, and he basically puts on Instagram and different things too. And I know we put it on our website before that you need to have insurance, and this is why.
Wow, that's great. Thank you. Let's transition to Will's power of attorney executor.
Okay.
There's some, here's another question. There is some misunderstanding about power of attorney before the person dies, and then the executor of the estate after the person dies. When does the authority of the power of attorney end?
As a matter of fact, I used to be a commissioner in probate court, so I served as a judge that handles all the estate and deals with the power of attorneys, etc. If you have a power of attorney, that power of attorney ends at the death of the person that gave you the rights to basically be their power of attorney. So an executor is one that's appointed by the court when you basically either petition and file the person's last will and testament if they died with a will, or you open what's called an intestate estate, meaning the person that died without a will. Then that person is qualified if they're over the age of 18, have not been convicted of a felony. Then they basically are appointed to be the executrix if it's a female, or the executor if it's a male, to basically serve and carry out the wishes of that person's will, or either basically pursuant to the laws of intestate succession in the state of Indiana as to how that property is to be distributed.
All right, thank you. You know, as pastors, sometimes we encounter situations where someone was power of attorney and then the person passes away, and then who has the authority to begin making funeral arrangements, the whole gamut. So it's important that you said at the death, that power of attorney ends.
It does. And the thing is this, is that Indiana, basically in terms of funeral, has a hierarchy. It would be the surviving spouse, if there's a spouse, that has the right to make those funeral arrangements. If there's no spouse, then it falls basically upon the children itself. If a person has a will, then that person that basically is designating the will then would have that particular right. With the power of attorney itself, if they designate, if they want this person to basically carry out their funeral wishes, then that power of attorney is going to be looked at by a judge or anyone else, even though it's not effective at the time that they die, but those wishes are still there. The same with the will.
All right, thank you, thank you. Let's move to a hot topic. We have a question about parents' rights regarding schools.
Okay.
Parents have children in school. Can they visit the school at any time? Can they walk into the classroom at any time? Can they review the curriculum at any time? Because there's a lot of noise right now about parents' rights. Can you help us in that area?
You know, I don't practice within that area, so I don't know a lot about it, but I think that you should not just walk into a school situation because they can say that's disruptive. And you have a right to basically review the curriculum with the administration and also with the teacher. They have to basically share that information with you. I think that they can't keep you from coming to the classroom if you basically give them notice that you're going to be there to find out what's going on. I think any school that basically is educational and open is going to invite you to come in. And they're going to be transparent about what's going on in the classrooms, what's being taught. So, I mean, that's the extent of the knowledge that I really have, because it's something I don't practice in.
Okay. And what do you advise for parents if they're having an issue with the schools? At what point do you think that a parent should engage an attorney?
Well, if they're getting pushback and they're not getting anything accomplished itself with the administration, or if they're going to the superintendent of the school district and they're not getting anything done, then at that point in time, I would contact an attorney that does school law, is what I would do.
Okay. And let's take one more question.
Okay.
And it is regarding potholes.
Okay.
When we receive damage to our vehicles, whether it's tire damage, structural damage, what's the process? If you can give us a generic answer, because I know you're in Annapolis, but what's the overall process that a citizen should take if they encounter a pothole and there's damage?
Well, you know, the thing is, it's going to be applicable to Howard County and also Marion County, where I'm at. You have to give the city what's called a tort claims notice, which basically means that there has to be written notice of your damage filed with the city within 120 days of that damage itself. Now, I know there's been some agencies that are keeping track of potholes in different locations on the roads, because number one, the city has to be aware that that pothole is there. It had to be basically reported to the city, and they failed to alleviate that hazard or to fill that pothole in. But if they don't know about that pothole, then you don't get your recovery for anything that happens to your vehicle. So, I mean, there are agencies, and there's been people basically in reporting. We have what's called a Marion Center here. I'm not sure if they have that in Howard County. And that's where the reports for potholes and things are made. And there's also some kind of an interactive map, I don't know the name of it, that we have reported potholes to the city because the city was not paying for potholes.
Okay, so yeah, I know we're out of time, but I just want to follow
Oh,
up
we're
real
fine.
quick.
I'm good.
Okay, I just want to follow up real quick. So if you have an encounter with a pothole and you're the first person that reports it, you can't recover a
The city
claim?
typically would, city would typically not pay you unless you can basically prove that the city had knowledge the pothole was there. Now, I have had a case where basically an accident happened and that pothole itself had not been reported to the city, and the person sustained some very serious damage to the car and also to their person. And basically, I was able to get around the cities. They filed what's called, if we filed suit on that, which we did, they filed what's called a motion for summary judgment, trying to get the case thrown out. And
Mhm.
what I was able to do was find an old case that was basically early 1900s that basically said if the city workers basically was in that area and they had basically been working and doing some things within the vicinity of that pothole, then they should have constructive knowledge. So the city may not have had actual knowledge, but if you can prove constructive knowledge, that will suffice. So I was able to prove that basically city workers had been in the area doing things, electrical, et cetera, and that they should have known. And
Wow, that's
that's their
great.
responsibility to pass that on.
That's great. Well, Attorney Hamilton, we certainly appreciate the valuable information that you shared with us on today. This has been an amazing session, and you're free to share your contact information, or if anyone wants to reach out to you. Are you comfortable sharing that information?
Sure, sure. My name is David Hamilton. I'm with the firm of Rowan Hamilton, and we're located in Indianapolis, Indiana. My telephone number is 317-632-2524. I also correspond by email at dwhamilton, HAMILTON, law, LAW, at gmail.com. And
Thank
Pastor,
you.
thank you so much. I have been blessed today to be in your presence.
You're welcome. You're welcome. And for those of you that are viewing and those of you that would like to share this information with your family and friends, it will be posted on our church Facebook page, Temple of Faith, Church of God in Christ in Kokomo. It will also be posted on our YouTube channel, Temple of Faith, on YouTube. Please share this valuable information that Attorney Hamilton gave us on today. We also want to invite you to worship with us at Temple of Faith, Church of God in Christ, at 2117 North Apperson Way. We're off the corner of Apperson and Morgan in the great city of Kokomo, Indiana. You're welcome to join us on Sunday mornings at 12 noon and Wednesday evenings for our virtual Bible study at 6 o'clock Eastern Standard Time on our Facebook page. We hope that this information shared today will benefit you and your family. Please join us next month for our Saturday morning breakfast conversation. Monitor our Facebook page for the topic for the month of April. And we truly believe that if you encourage others to join with us, that all of us will be better. Our lives do not improve by chance. Our lives improve by choice. So let's start making the right choices in our lives. Thank you. Thank you again, Attorney Hamilton. Thank you for all of our viewers. And we look forward to being with you again next month for our Saturday morning breakfast conversation. Have a great day.
Thank you.